Thanks to Judicial Watch, it now is going to be easier for federal candidates to stop an election from being stolen. Honored to announce that the Supreme Court of the United States agreed with Judicial Watch. We won 7-2 before the High Court on a very important election integrity issue. The question of whether candidates have the right to challenge election rules in federal court, have standing to challenge. In this case, we represent Mike Bost, Congressman from Illinois, two presidential electors who technically were federal candidates as well, who are challenging Illinois' law that allowed the counting of ballots that arrived for up to 2 weeks after Election Day. That means ballots could be as late as 14 days after Election Day and still get counted. Now, federal law sets on Election Day, not on Election Week, not on Election Month, but the court didn't want to get at the merits. They said a candidate didn't have standing to challenge this. And they said, well, he was going to win anyway. We're like, well, that's ridiculous because he has a right to an accurate count. He has an inherent right to challenge unlawful election rules on making him, for instance, spend money and time and effort and concern and anxiety related to the counting of ballots that occur after Election Day. And the Supreme Court agreed with us completely and came up and concluded, really affirmed what has been the law prior, frankly, to 2020, that candidates have a broad standing right in federal court. Again, it was 7-2. It was 5 votes in favor of the broadest possible standing, 2 votes in favor of a narrow standing but pretty broad standing, and then the 2 left-wing justices, Justice Jackson and Justice Sotomayor, filed a dissent. Now, the big majority opinion, the 5, so what happened is Chief Justice Roberts wrote the majority opinion. He was joined by Justice Thomas, Justice Alito, Justice Gorsuch, and Justice Kavanaugh. Concurring in the opinion was Obama appointee Elena Kagan and Justice Barrett. And they agreed that candidates did have the standing to challenge such a rule, but they said they only needed to allege pocketbook injuries, meaning spending money would be enough, or should be the hurdle they have to meet. And Chief Justice Roberts, in his opinion, rejected that in his broad analysis. And this is the way Chief Justice Roberts, I think I got a copy of the way, this is what it looks like when it's published officially. I guess it's white, so you really, maybe I could hold it up against the blue, make it more blue. Can you see it now? Well, I guess you really, it doesn't matter. And I encourage you to read the decision in its entirety. It's available below. We'll provide a link. To start, candidates, Chief Justice Roberts writes for the 5-judge majority, candidates also have an interest in a fair process. Candidates are not common competitors in the economic marketplace. They seek to represent the people, and their interest in that prize cannot be severed from their interest in the electoral process, a process, quote, of the most fundamental significance under our constitutional structure. Win or lose, candidates suffer when the process departs from the law. Thus, the long shot and shoe-in alike would suffer harm if a candidate chose to conduct its election by, say, flipping a coin. The result of such an election would not reflect the will of the people, and the candidates would lose the opportunity to compete for the people's support. So too, similar harms would result from less dramatic departures. For example, if a state decided to discard a random 10% of each vote. Whether these decisions help, hurt, or have no effect on a candidate's electoral prospects, they deprive the candidate of a fair process and an accurate result. So, if there's gaming, potentially, of the way ballots are counted, as our lawsuit alleges for Congressman Bost, the Supreme Court said, yes, you can sue. And contrary to what Justice Barrett and Justice Kagan suggested, you don't need to spend money in order to sue. because what Chief Justice Roberts wanted to do, and his colleagues, he wanted to be sure that the less courts are figuring out what happened after an election, the better. By suggesting they got to spend money, it means they got to go through the process before maybe a prima facie violation of the law is challenged. I mean, in this case, our client was told he couldn't challenge the law because he won by too many votes. You know, that's absurd. And further in the lawsuit, further in the opinion, I should say, candidates have a concrete and particularized interest in the rules that govern the counting of votes in their elections, regardless whether these rules harm their electoral prospects or increase the cost of their campaigns. Their interest extends to the integrity of elections and the democratic process by which they earn or lose the support of the people they seek to represent. That's a pretty powerful statement. Candidates' interests extend to the integrity of the election. Now, great victory for our team, and that's worth all of the election work Judicial Watch has done to get a result like that. What a tremendous and powerful vindication of all the concerns Judicial Watch and others have had about what we believe to be shenanigans in the way elections have been run. And isn't this decision about 2020 in many respects? Because in 2020, you may remember, when candidates sought to challenge election rules, they were told it's too soon. It's too soon, no harm. Or if it was close to the election, it's too close to the election. Or if it's after the election, it's too late. Here, there's no real question that candidates, assuming there's a valid claim, meaning they make a credible case there's a federal or constitutional issue, a federal statute at issue, or a constitutional violation, they can go into court, and there's no question about the standing. I mean, the idea that someone like President Trump might have the standing, might not have had the standing because he was challenging something too soon, or the challenge may have been incidental to or immaterial to the outcome of a race, that's done. And unfortunately, the court didn't deal with it in 2020, but they're dealing with it right now. So it's a significant victory, and I can't give enough credit to our legal team for getting us here. I can't give enough credit to you, dear supporter, those of you who have supported our work, not only prayerfully, but with actual financial contributions to getting this awesome result. And it is an awesome result. This is the statement I issued on behalf of Judicial Watch. This is the most important Supreme Court election law ruling in a generation. Too many courts have denied candidates the standing to challenge unlawful election rules, such as the outrageous ballots that arrive and are counted after Election Day. American citizens concerned about election integrity should celebrate this Supreme Court victory. I thank Judicial Watch's legion of supporters and our election law team that helped achieve this historic result. And of course, Bob Popper leads our election integrity team here. Russ Nobile, also a veteran election lawyer, specifically shepherded this case, and our longtime team member and attorney, Eric Lee, has also been working diligently on these issues as well. And we were aided before the court by Paul Clement, a veteran Supreme Court litigator, and Christine Venson, who's been helping us in Illinois managing a case there as our local counsel. But I just can't tell you how excited I am, and I guess it really is a remarkable vindication of those of us who were concerned about the way the courts operated in 2020, because essentially Chief Justice Roberts says we mishandled that the courts did not give credence to the rights candidates have to try to settle controversies about the integrity of the election. Now, in some ways, he says, well, this is all about ballot counting, only about ballot counting. Well, you know, that's a lot. You know, pretty much everything elections are disputed over relate to ballot counting. That gamesmanship where they changed the rules at the last minute and told people they couldn't challenge them until after the election or until after we knew what the impact is, that's not the standard anymore. Now, interestingly, as I noted, 2 justices agreed with the result that candidates had standing to challenge this, what we allege to be illicit counting of late ballots. But Justice Barrett and Justice Kagan said, well, they need to allege a pocketbook injury. And the response that Chief Justice Roberts had, well, that doesn't, it just raises the issue of when judges are going to be able to handle this. Because if there's a legal issue, a candidate shouldn't have to spend money in order to vindicate his right here to have a process that's legal from the get-go. And as he highlighted, some people don't necessarily spend money in campaigns. You get insurgent candidates that are just operating on shoestring budgets practically. And so that doesn't really solve the issue in terms of providing standing to candidates to vindicate our system. Now, the leftist justices, more left, Justice Kagan's pretty left, but not reliably so in certain issues, they issued what I consider to be a partisan dissent, saying, well, this is just a brand new standing standard. It isn't. And it's going to unleash a deluge of cases. It won't. First of all, it costs money to engage in litigation, so if it's a stupid reason, campaigns don't have the money to engage in stupid litigation. It's got to be litigation that's credible and it's going to have an impact on the campaign in a way to justify the use of precious campaign resources to engage in litigation. And if the litigation isn't credible, courts deal with incredible litigation all the time, and it can be handled appropriately. So that was, to me, not a terribly persuasive, because sometimes dissents raise things that are credible, right? And you've got to pay attention to them. Justice Jackson, we may not like her, but sometimes she raises she writes a dissent here and there that makes you think, she has a fair point. So it's important that you read the full decision, and I'll give, to be fair to the other justices, give them give them your full attention as well, and see if it's persuasive to you. But in terms of the law, in terms of the way the law is now applied, our candidate, client, Congressman Bost, is now going to be able to challenge this rule in Illinois. What next? Well, we're in the Supreme Court already on the underlying merits of the issue, whether states can, contrary, we allege, to federal law, count ballots that arrive after Election Day. In Illinois, they count ballots for up to 2 weeks after Election Day, sometimes even without a postmark. We have a challenge there. In California, we had a challenge for Congressman Issa. They count ballots that arrive for up to 2 weeks after Election Day. I talked about this last week. I talked about how 2026 is going to be a big week or a big year for election law because of Judicial Watch. Well, I told you, the Supreme Court just ruled. And now the Mississippi case is before the Supreme Court. By Mississippi, it's called, I think it's called Watson is the shorthand way of calling it. So the Watson case out of Mississippi, we challenged Mississippi's counting of ballots that arrive for up to 5 days after Election Day. And the lower court on the merits said, no, you can't do that. And the Fifth Circuit said, no, counting ballots that arrive after Election Day is unlawful. And so the Supreme Court is going to figure that out one way or the other, we suspect. They wouldn't have taken it up, I think, if they didn't want to decide the question this term. So right now we're in the middle of the briefing on the issue. We expect the oral argument. I thought it might be in March. It looks like it might be in April now, with a decision by the end of the term, usually by June 30th. So huge developments. And when you look at the majority opinion, it seems to augur well for how the court majority will rule as to whether you can count ballots that arrive after Election Day, which in my view is in plain violation of federal law, which sets an election day. It invites fraud and undermines voter confidence. And I tell you, if the court knocks that out, our elections will, by an exponential way, all of a sudden be more honest, because they won't be having ballots come over the transom through the mail after Election Day to change outcomes. I noted last week, it's worth noting again, there are 2 members of the House of Representatives who are in office as a result of ballots they came in and were counted after Election Day. And they're Democrats. They beat 2 House Republicans. As far as I'm concerned, the House Republicans would be within their rights to seat the Republicans whose seats were taken from them as a result of this illicit counting. They don't need a Supreme Court decision to judge the election. The House can do it under the Constitution directly. So this late ballot counting matters, is my point. And so to enforce the rule of law, restore voter confidence, and guard against fraud, they've got to set the rule in place or reaffirm the rule. I mean, when you look at all the amicus briefs that were filed, I think there were like 16 or 17, all these leftists are apoplectic about this little scheme being thrown out by the Supreme Court about post-election day counting of ballots that arrive late. So they should be nervous, because they know what they're. Because I think they know that we got their number, and I think they're worried the Supreme Court, certainly after reading this decision, may have their number as well. So great work by Judicial Watch. And Russ Nobile, who had been shepherding this case up until the Supreme Court, he made a comment about it just the other day.
Hey everyone, Russell Nobile. I'm one of the election integrity attorneys here at Judicial Watch. A big day for us here at Judicial Watch, whereas the Supreme Court agreed with us and reversed the federal courts in Illinois' decisions, throwing out our election integrity lawsuit there, challenging Illinois' practice of allowing ballots to come in 14 days after election. We're representing Congressman Mike Boss there, along with 2 federal electors. The court in the 7-2 decision basically adopted everything we said and said the courts are wrong to throw out our lawsuit. The court talked about the different issues as to why federal candidates have standing, and the court ultimately decided it doesn't matter so much whether the candidate's going to win or lose the election. Candidates have an interest in making sure the vote count is accurate, and even if he wins by a large margin, because it costs him more money and causes him problems in making sure the election is run with integrity. And so this is part of a multi-year strategy to get federal courts to finally answer why these ballots are coming in days and weeks after election. We have another case that's pending before the Supreme Court right now. That's a case out of Mississippi that we won in the Fifth Circuit. That case is part of the, will finally presumably answer once and for all why these ballots can come in days and weeks after election. We think this is a really important issue to stop this really sort of banana republic practice of allowing ballots to come in days and weeks after election. Thank you for all of your support, and we'll have more information to come on the cases.
And then here, Congressman Boss, I have to thank him. I mean, it's not easy to get a client, and certainly a sitting member of Congress, to take on a fight like this. So Congressman Boss deserves some kudos for standing in the gap with Judicial Watch as our legal team represented him. He said, "I'm thankful the U.S. Supreme Court has ruled strongly in our favor and concluded we have standing to challenge Illinois' unconstitutional law allowing vote-by-mail ballots to be counted 2 weeks after Election Day. This is a critically important step forward in the fight for election integrity and fair elections. I look forward to continuing to pursue this case as we navigate the next stages of the legal process. It's vitally important that we restore the people's trust in our elections." Amen. Amen. So, thanks to Judicial Watch, it now is going to be easier for federal candidates to stop an election from being stolen. Okay? That's the point of this case. So if they decide to count ballots that shouldn't be counted, contrary to law, a candidate can get into court a lot more easily and stay in court to litigate and vindicate the rule of law and his rights as a candidate. Something that, in my view, was denied improperly to Trump and others in 2020, and that game is no more. That game, the game rules have changed. They changed the rules to keep Trump out, and the Supreme Court fixed the rules to allow similar challenges in the future that have merit. I mean, what you're afraid of? You're afraid that someone might actually make the merit case that an election has been compromised, and in order to avoid that, you say you can't even be in court to make the case? Well, the court didn't find that to be appropriate. The Supreme Court did, and hence this decision. So great news out of the Supreme Court of the United States. Big news, one of the most important Judicial Watch victories since we've been around 30 plus years.
Thanks for watching. Don't forget to hit that subscribe button and like our video down below.